My name is Benoît Stockbroeckx. I'm Technical Manager for Euralarm, the European Association of the Electronic Fire Safety and Security Industry. We are today on the 4th of July 2022, and it is a pleasure for me to sketch for you the status of the EU regulatory landscape on cybersecurity with the already existing pieces of legislations and those announced for the near future. The first European directive enforcing cybersecurity requirements has been published 8 years ago, and the arrival of the Commission von der Leyen triggered an acceleration of the initiatives on this topic. The State of the Union address of September 2020 by the Commission's President announced the target of a digital sovereignty for Europe at the horizon 2030. Such an ambition cannot be envisaged without a robust cybersecurity strategy, which has been announced in December the same year. The strategy focuses on two targets: the security of essential services and the security of ever-increasing number of connected objects. You will see that these two targets are addressed by existing legislations or new ones in preparation. I can also mention the Digital Compass presented in March last year, which confirms the need for secure digital infrastructures. The very first piece of legislation addressing cybersecurity has been published in 2016. It is the Directive on Security of Networks and Information Systems, known as the Nis Directive. It aims to enforce a culture of security and cybersecurity for critical infrastructures. So, this legislation provides mandatory requirements for processes and services, mainly. A new legislation on critical entity resilience is currently in preparation. It is great in the slide because it hasn't been published yet. This CIR directive will enforce the protection of critical entities against natural disasters, terrorism, or health emergencies. As it doesn't cover the cyber threat, the European Commission proposes to complement it by a revision of the Nis Directive and to align the scope of both. This new CER directive will sit together with the Nis in the area of mandatory requirements for processes and services. Another existing legislation is the Cybersecurity Act. It has been published in 2019 and defines a framework for the development and the application of cybersecurity certification schemes. By default, these schemes are intended to be used by the market on a voluntary basis. Buyers can request from their supplier that the products, processes, or services are certified according to a published scheme, and suppliers can differentiate themselves from their competitors by claiming certification according to a certain scheme. As these schemes are intended to be used on a voluntary basis, they target a higher level of cyber assurance than the minimum requirements for the free circulation of goods enforced by other pieces of legislations. However, the European Union and member states may impose by law the application of certification schemes in order to enforce the protection against specific concerns. One interest of the Cybersecurity Act is the obligation for the member states to withdraw their conflicting national schemes as soon as European one has been published. This is intended to avoid the creation of a patchwork of national legislations across Europe and so decrease the burden, the costs, and the legal uncertainty for the suppliers. ENISA, the European Agency on Cybersecurity, is empowered by the Cybersecurity Act to develop the certification schemes, and the member states are required to organize the certification in their territories. The CSA introduces 3 levels of assurance in order to address different levels of risks. No certification scheme has been published yet, and we are concerned by the slow progress made by ENISA on the development of the schemes. In particular, the schemes covering IoT and industrial and automation control systems are awaited by the alarm industry. Euralarm is eager to contribute to the development of the IoT and IACS schemes with the help of Senelec TC79 and via the Senelec GTC13. We now understand where the CSA sits in the EU regulatory landscape. It provides certification schemes for voluntary use applicable to products, processes, and services. A very recent piece of legislation is the delegated regulation enforcing three essential requirements of the Radio Equipment Directive. It has been published early this year and puts into force cybersecurity and privacy-related requirements in the context of the new legislative framework for the free circulation of goods. These new requirements so appear in a sectoral legislation covering radio equipment next to the other sectoral legislation which also recently incorporated cybersecurity requirements like the Medical Device Directive, the In Vitro Diagnostic Regulation, and the Future Machinery Regulation. The standardization request will be presented to CEN and CENELEC by mid-July, allowing them to prepare harmonized standards to be cited in the official journal of the European Union. All the products in scope of this new delegated regulation shall comply to the new requirements by the 1st of August 2024. A critical aspect of these new essential requirements is that harmonized standards need to be cited in the OGEU to allow manufacturers to demonstrate compliance by a self-assessment and get presumption of conformity. In case no standard is cited in time, the manufacturers will have to undergo a third-party certification via an RED notified body. This is a real concern for the industry because, at first, this will create a bottleneck due to the limited number of RED notified bodies. Second, the notified bodies won't have a common technical guideline to assess the products with a common procedure. And third, this will imply longer delays and costs before placing the products on the market. Euralarm contributed during the last 2 years to help the European Commission making the scope of these new essential requirements proportionate, to improve the clarity of the standardization request and to the preparatory work at standardization level with CENELEC TC79 and CEN-CENELEC JTC13. The overall goal being to make self-assessment possible. Where sits this delegated regulation into the EU landscape? It obviously provides mandatory requirements on products. The last piece of legislation under preparation is the Cyber Resilience Act. It is intended to be a horizontal legislation covering tangible digital products and embedded software, regardless whether they are wired or wireless. It is expected to provide for CE marking of the products in order to ensure their free circulation within the European Union. The draft text for the European Commission is announced for the third quarter of this year. Euralarm is supportive of this initiative because it will provide the same requirements for all the products, and this is seen as a more consistent approach than having different requirements in separate sectoral legislations, like we see with the RED. Euralarm again asks for proportionate scope to avoid unproductive burden for manufacturers. We advocate for a system where the manufacturer defines and commits to the time period during which security updates will be released instead of a firm duration laid down in the legislation. This request is justified by the diversity of intended uses and environments of applications. We also advocate for self-assessment being the norm in this new regulation, even if we agree that third-party certification could be justified for certain intended use with very high cyber risks. Where sits this CRA into the EU landscape? Next to the Radio Equipment Directive by providing mandatory requirements on products. With all these pieces of legislation, we now have sketched how the EU cybersecurity regulatory landscape will look like in the very near future. I hope this presentation has been of any help for you in the understanding of how these various legislations complement each other. Euralarm thanks you for your attention and encourage you to share it within your organizations.